Welcome back to Counting to Five, a podcast about the United States Supreme Court. I'm Mike, your host, and this is our weekly YouTube live stream being broadcast live Thursday, May 10th, 2018 at 9 p.m. Eastern Time. This live stream will also be posted as an episode of the Counting to Five audio podcast. If you're watching live, please feel free to ask questions in the YouTube live chat at any time, and I'll try to monitor that and periodically answer questions as they arise. And in these weekly live streams, we try to keep up to date with the latest Supreme Court news, but as you'll see, there's not a lot of news this week, so we're doing something a little bit different. Here's what I plan to cover today. As I mentioned, it's been a very quiet week at the court. As expected, the court didn't have a whole lot going on this week. There was no court sitting this week. The court didn't issue any new orders list, and there were no new opinions issued. I do have a couple brief pieces of news. The court did rule on a last-minute death penalty stay application this past Friday, and there was also an interesting lower court development related to one of the cases on the Supreme Court's docket this year. So I'll talk about those things briefly, but on last week's live stream, because we were expecting this to be a slow news week at the court, I asked for viewer and listener questions. I got a few of those, so after we get through the brief pieces of news, I'll turn to those questions. Again, if you're watching live, feel free to ask your own questions in the live chat. So let's dive in, and we'll first talk about the couple new developments this week. The first is another in the series of death penalty stay applications, a regular feature of the court's docket. And if you've been watching these or listening to these live stream episodes, you've heard this as a recurring feature of what of the court's work. But there was another of these. Now, this was a death row inmate named Robert Butts, and he had originally been scheduled for execution last Thursday, May 3rd. I had been expecting to cover his stay application for him last week. However, let me give a little background first. So he's a death row inmate in Georgia. He was convicted and sentenced to death for a 1996 murder of a former coworker, which was allegedly committed in order to improve his status in a gang that he belonged to. In any event, he was scheduled to be executed last Thursday. The day before, that's Wednesday, May 2nd, the Georgia Board of Pardons and Paroles granted a 90-day stay of the execution to give them more time to review his case. So as of May 2nd, his execution had been temporarily at least called off. However, the very next day, Thursday, the day he was originally scheduled to be executed, the stay was lifted. The Board of Pardons and Paroles lifted their stay, and then the execution was rescheduled for Friday, the following day. So on Friday, his legal team filed an application with the Supreme Court to stay the execution. His basic legal theory revolved around there's I guess two different theories he was arguing to the court, both under the broad category of cruel and unusual punishment under the Eighth Amendment. One was an argument that under current sentencing standards, Butts wouldn't have been sentenced to death. The key fact they point to is the murder he was convicted of was a murder involving only a single victim and only a single aggravating circumstance. Now, aggravating circumstances are special kind of facts related to a murder that make it particularly culpable, and that's one thing that juries that are sentencing someone to death are required to find, is that there's some aggravating circumstance that makes it more than just any old murder, I guess. But this was a single victim in a single aggravating circumstance, and he argues that basically currently in kind of modern day practice in Georgia, no one is executed, or no one is given a death penalty with only a single victim and a single aggravating circumstance. And he says that since 2006, there haven't been any Georgia death sentences with a single victim and single aggravator. And he argues that a key consideration by the courts in thinking about cruel and unusual punishment is proportionality. And he says that this is a disproportionate, given that these types of crimes are not normally punished with a death sentence. So that was one argument he made to the court. And the other was related to his age. Now, he was 18 years old at the time of the murder. There was a Supreme Court case called Roper v. Simmons in 2005, where the court held that it was unconstitutional to execute someone who committed a murder while they were under the age of 18. So someone who committed a murder while a minor could not be constitutionally sentenced to death. And the court pointed to factors like that, it said that minors, there's social science evidence that shows that minors lack maturity. They don't have a sense of responsibility. They're prone to reckless behavior and vulnerable to peer pressure, and often lack control over their environment. And so the court held that because of these various factors, they were drawing a line, and anyone under 18 at the time they committed a murder could not be sentenced to death. Now, in this case, Butts' counsel argues, even though he was over 18, I guess just slightly over 18, they argue, well, two things. Basically, they argue that the 18 cutoff is arbitrary, and that actual good cognitive science research shows that the immaturity that the court was pointing to in the Roper v. Simmons case actually extends into the early 20s, and so that the fact that he was a little bit over 18 shouldn't exclude him from the reasoning in that opinion. And they also made another argument that due to his low IQ, they say that Butts was actually mentally equivalent to a 15-year-old. And so even though he was chronologically older than 18, he should be considered comparable to a minor. But later on Friday, the court apparently did not see any merit to either of these theories and issued an order denying his stay application. There were no noted dissents, and Butts was executed later on Friday evening. So that brings us to the next. That's all for that one. The next is there's an interesting development. It's related to one of the cases that's on the court's docket this term. It's a case I've talked about in previous episodes, and it's a case that we're still waiting on for the court to deliver an opinion on. And the case is called Western Geco v. Ion Geophysical. And this is a patent case, and it's about damages for lost profits that would have been earned outside the United States, and whether the patent statutes allow someone to recover lost profits that were not within the that would not have been earned within the geographic United States. And it was about some patents that relate to mapping the ocean floor for oil and gas exploration. Now, the case involved 4 patents that were owned by Western Geco, and Western Geco had sued Ion Geophysical for patent infringement on these 4 patents. Now, at the same time as this Supreme Court litigation is going on, there's been some parallel proceedings happening in a different forum. So another oil exploration company called Petroleum Geoservices, Inc., that was also involved in litigation with Western Geco about these same patents. They brought an action for an inter partes review, or it's referred to as IPR for short, with the Patent Trial and Appeal Board, which is part of the PTO, the Patent and Trademark Office. Now, inter partes review, or IPR, that's something I've discussed also in some previous episodes of this live stream, because the Supreme Court earlier this term decided 2 cases that were about that IPR process. But basically, in short, what it is, it's a adversarial process within the PTO to have the Patent and Trademark Office re-examine a patent that's already been issued to see if it should not have been issued, if it's actually invalid and should not have been issued. So what happened is this other company, Petroleum Geoservices, brought this request for an IPR, the inter partes review, and the Patent Trial and Appeal Board, they chose to review, they have discretion whether or not to initiate one of these reviews. They chose to review 3 of the 4 challenged patents. The 3 patents that it reviewed, they found all 3 of those patents invalid, finding that they didn't meet the non-obviousness criteria, meaning there was prior art out there existing out in the world that anticipated these patents, so they weren't non-obvious, therefore they're not eligible. They were not eligible to be patented. So they found that these 3 patents were invalid. Now, this decision of the Patent Trial and Appeal Board was appealed to the Federal Circuit Court of Appeals. That's a specialized federal appeals court that hears patent-related cases, and they hear appeals that come directly from the PTO. And that court, the Federal Circuit Court of Appeals, on Monday this week, that's May 7th, they issued an opinion. That court issued an opinion affirming the Patent Trial and Appeal Board's decision invalidating these patents. So affirming the decision to invalidate 3 of the 4 patents that are at issue in this case pending at the Supreme Court. So it's interesting. Now, the Supreme Court, the issue that's being litigated in the Supreme Court is still a live issue. There's still that 4th patent that's still that hasn't been touched by these the lower court ruling. So there's still the issue of damages related to that 4th patent, and so the issue is still live. But it's just, I found this interesting because it just illustrates that these kind of legal disputes, they often have multiple moving parts, and it's not unusual for there to be related litigation going on simultaneously in different venues, different states or different courts. Here it's 2 different parts of the federal system, and although the Supreme Court has the final say generally on the legal issues it decides to hear, like in this case, the issue of whether someone can earn extraterritorial lost profits. Sometimes the impact of a decision can be undercut from other directions, and even though the Supreme Court technically had the final say on that issue, for the parties in this case, a huge amount of the damages are going to disappear, not due to anything the Supreme Court says, but likely due to the invalidation of some of the patents the damages were based on. So just thought that was an interesting note on one of the cases we're waiting on. We expect a decision from the Supreme Court in the Western Geco v. Ion Geophysical case just any time between now and the end of June, as with all the rest of the court's pending cases. They could any time between now and the court's recess for the summer. So with those bits of news out of the way, I'm going to move on to some listener questions. And I asked last week for some listener questions, requests, if anyone had them. I only got a few questions, but they touch on some interesting areas and kind of give me an excuse to go into some background about the court that I hope will be interesting. Again, as always, if you're watching live and have any questions of your own, feel free to ask them in the live chat. But I have several questions that came from listener Ryan Briggs. And 2 of the questions are about the Supreme Court's regular orders lists. So I'm going to give a little background first about the orders list, just to explain for people who aren't familiar what that is, what those are, and then I'll try and answer the questions there. So the Supreme Court regularly issues orders relating to the cases on its docket or other requests that are made to the court, and these orders, they can be found on the court's website. If anyone's interested in seeing them, you can find them by choosing the menu for case documents and then selecting orders of the court. And those orders are arranged chronologically by the court's term. Now, the court's term runs from October through the following September. So we're currently in the 2017 term as the court names those terms. And the orders are listed chronologically, and orders are basically, they're released in 2 different ways. There are regularly scheduled orders lists, which the court releases on a very predictable basis, and they have a large, usually quite a few orders over multiple pages on various cases. And then the court also issues miscellaneous orders, and these are more sporadic and unpredictable. So the orders list, the court has regular private conferences throughout the term. So the justices meet in private conference to discuss various business before the court. And from October through April, those are the months that the court hears oral argument during the term. And each month during the term, it hears 2 weeks of oral argument. And it will typically have its private conferences the Friday before each 2-week argument session, and then the Friday of each of those 2 oral argument weeks. So basically 3 conferences per month is the basic schedule. Now, it's not always exactly 3 conferences a month, because those 2-week oral argument sessions, sometimes they overlap off the beginning or end of a month, so they're not all actually fully within the month that it's named after. So something maybe called the November conference, but it may actually start in the end of October, for example. So it's not exactly 3 conferences per month, but on average 3 conferences per month around immediately before and during the oral argument weeks of that month. And then in May and June, at the end of the year, they basically have a conference every Thursday in the this end part of the term. They have a conference today, May 10th. They had a conference earlier today, May 10th, and it'll be every Thursday after this year until June 21st. That's their last scheduled conference on their calendar. And what they do is the Monday morning following each conference, each of those conferences, typically at 9:30 a.m., the court releases an orders list, which has the orders that result from decisions that were made at the private conference. And in a few minutes, I'll discuss kind of what these orders lists look like, the types of orders that are included on those lists. Now, I mentioned also that the court issues miscellaneous orders. These typically are things that deal with more time-sensitive matters, things that can't wait for a regular conference and a regular orders list. So a common one is requests for emergency stays. When someone makes a stay application to the court, for example, granting or denying or an application for a stay of a death penalty. When the court issues its order granting or denying that application to stay a death penalty, that will come out in the miscellaneous as a miscellaneous order, because it'll just be released immediately as soon as the court is ready to release it. It's not waiting for a Monday morning orders list. The court just rules on those emergency things, so its ruling is out there and can be acted upon. Occasionally, even decisions that come out of a conference that are normally the type of thing that would make it on an orders list, occasionally those things will be issued as a miscellaneous order if it's particularly time sensitive. One recent example of that was on Friday, April 13th, so it was only a month ago. The court issued a miscellaneous order, and it addressed motions in 8 different cases concerning the division of time at oral argument. So this is, for example, allowing the Solicitor General, that's the government's representative who argues on behalf of the federal government in the Supreme Court, allowing the Solicitor General to participate in oral argument in several cases. Now, this was Friday, April 13th. The April oral argument session started the following Monday, the 16th, and one of those orders allowing the Solicitor General permission to participate in oral argument was for a case that was being argued on that Monday. So the court couldn't really wait until Monday morning's orders list to announce that it was allowing participation in Monday's oral argument, so it puts it out Friday as a miscellaneous order. So that's just kind of an exception to the normal flow of things due to the time sensitiveness and the court wanting to get that out quickly. So what does the orders list look like? What does it typically consist of? Well, the orders list from week to week or conference to conference, the list, it varies in length, and the specific makeup, exactly what's included or not on the orders list, varies from week to week. But there are a number of common categories of orders that recur frequently. Now, some common features of all the different types of orders on the orders list is that in general there's no vote breakdown. The court just orders, issues an order that some request or some application or some petition is granted or denied, and there's no indication of any vote, how many justices were for or against that decision. Now, justices can optionally record a dissent. They can indicate that they dissent from one of these decisions, but that's extremely infrequent. It's very rarely done, and generally there's just no indication of who voted for or against these things. Occasionally, when a justice wants to register a dissent, very rarely there'll be just a single sentence, perhaps citing a case or something like that, indicating that some justice is dissenting for some reason. And slightly more often than that, there will be what's known as there will be a separate opinion relating to an order. And these are usually short opinions that are appended to the end of the orders list, where a justice is specifically writing out often a dissent from one of the court's orders, or some other comment, a statement relating to one of the court's orders. These are typically brief, sometimes as short as 1 or 2 paragraphs or a few pages. But once in a while, a dozen or more pages, they'll be somewhat longer. So those are the exception, though. The overwhelming majority of the orders on these orders lists are just a simple one-line order with no indication of which justices are supporting or opposing that order. And also these orders, they very frequently use very standard boilerplate language. So you see the same language repeated over and over again if you view enough of these order lists. So let me run through quickly. These are kind of some different common categories. This isn't, this isn't everything. This is just some of the most common things you'll see on the orders list, and not every one of these categories is going to be there every time. But one category of orders, this is the rough order that they usually appear on the orders list also. If there are anything in this category, it'll start with a category for summary disposition of cases. Now, this includes orders that are known as GVRs. And GVR stands for grant, vacate, and remand. And this is the court's process when there's a petition for the court to hear a particular case. And the court will, in some cases, grant that petition and then immediately vacate the lower court decision and remand the case back to the lower court. Now, the reason it does this is because generally because there's been, since the petition was filed or since the lower court decision was made, there's been some intervening legal development. Now, this is often a decision by the Supreme Court. So the Supreme Court may decide one particular case, and then there may be other petitions pending before the court on very closely related issues, or maybe the exact same legal issue brought up in other cases. And so the court will then grant those other petitions to immediately vacate the lower court decision and remand it, send it back down to the lower court, basically telling the lower court, take another look at this case in light of our new decision and see if that changes your result. Sometimes it'll be a different type of legal development. For example, if a new statute is passed by Congress that is directly relevant to some pending case, then the court might GVR in light of that statute. So that's the first category of orders that you may see on an orders list. Then there's often just kind of a hodgepodge of orders and pending cases. That's a category on the orders list, and that includes kind of a wide variety of different things. It's the court ruling on various motions for extension of time to file petitions, motions to appoint counsel in a case, motions for informa pauperis treatment. That's a petitioner who is asking to be allowed to have filing fees and certain other requirements waived in order to be able to file a petition without paying the costs usually associated with that. Another interesting category of type of order that's in this general category of orders and pending cases is what's known as CVSG for short, which stands for a call for the views of the Solicitor General. And this is when the court has a cert petition before it, and before deciding on that cert petition, whether to grant or deny that petition, the court asks the Solicitor General, and that's the representative of the federal government in the court, asks the Solicitor General to weigh in on this petition and whether the Solicitor General thinks this is a case that the court ought to hear. And the court often gives quite a bit of weight, apparently, to the Solicitor General's view in those cases. So the next category that's occasionally on these orders lists is cert grants, the category certiorari granted. So this is when the court has actually decided to grant a case and add it to its docket for oral argument. And usually this is just a simple one line that just lists the case the case name and the docket number and says that the petition for certiorari is granted. But occasionally there's more to it. For example, the court might add to or modify the question presented, which is the specific legal issue that the petitioner has asked the court to review. But usually it's just a very simple one-line thing granting the petition. Then there's the section certiorari denied. Now this is typically much longer, sometimes extremely long, going on for pages, just listing case after case after case that the court is denying. Now, if you've been following the court for a little while, you may know the rough numbers. Each year, the court gets something in the ballpark of 6,000 to 7,000 petitions for certiorari, and in recent years has only been granting somewhere in the ballpark of 70 or so. So there are huge numbers of cases that are just regularly denied week in and week out. And usually there's just no explanation, no notation, no nothing. Once in a while, you will see a notation that a particular justice was recused from a particular case. So it'll just indicate that Justice so-and-so took no part in consideration of this petition. Then there are a few other categories that you often see on these orders lists are related to petitions for habeas corpus, petitions for mandamus, and petitions for rehearing. Now, these are pretty much virtually never granted. Now, habeas corpus, you may be familiar with habeas corpus actions where prisoners are seeking to be released from custody because they say that they're being held illegally in some manner. Normally, there's a statutory framework for habeas corpus filings where a prisoner has to file their habeas corpus petition through the federal district court, and then it can work its way up to the Supreme Court through the normal appeals process from the district court. But there does exist original actions, petitions for habeas corpus directly to the Supreme Court, but it's virtually never granted. So it's kind of you will see these denials of petitions for habeas corpus, but I'm not sure when the last time one has been actually granted. There's also people may petition the court for writ of mandamus. That's for an order to a lower court or a government official to perform some sort of discretionary action. Again, those are virtually never granted from the Supreme Court. And then finally, petitions for rehearing. That's someone asking the court to rehear a case that the court has just issued some decision on. So they're asking the court to relook at something and kind of do it over. Again, those are virtually never granted. I don't know when the last time the court has granted one of those cases has. I assume at some point in the past those have been done, but it's extremely rare. And then the final category is attorney discipline, and this involves orders to show cause to particular attorneys, warning them basically that they're going to be disbarred from the Supreme Court, and then orders actually disbarring certain attorneys from the court. So that's kind of a rough idea of the types of things you see in these orders list. And again, they come out typically the Monday after the court's regularly scheduled conferences. But that brings me to the questions from listener Ryan Briggs. And he had two questions that were related to these orders lists. So I'll read one of them. He says, I occasionally see in the miscellaneous orders list where it says, the petitioner has repeatedly abused this court's process. The clerk is directed not to accept any further petitions in non-criminal matters from the petitioner unless the docketing fee required by Rule 38A is paid and the petition is submitted in compliance with Rule 33.1. All right, so that's kind of some standard boilerplate language that appears all the time. And he asks, how do they typically abuse the court's process, and how does the court decide enough is enough? So I can partially answer that. Let me give a little background first, just to understand what this all means. So these orders, they relate to the informa pauperis or IFP docket. So those are the unpaid petitions. These are people that are being allowed to file a petition without paying the normal costs. Now, normally, to file a petition at the court, you have to pay a filing fee, which I believe is $300 to file a cert petition. But more importantly, the court has very specific formatting requirements. And the briefs and documents filed with the court, they have to be printed on a unusual special sized paper bound into special booklets. There's very specific formatting requirement, including specific color coded brief covers. And the court is very particular about all of these requirements being met. And the court has to be provided with 40 copies of various briefs and filings. Now, parties that are litigating at the Supreme Court, they normally use specialized printing companies that have kind of expertise in filing these Supreme Court briefs, and there's a few of these printing companies that just have a business devoted to Supreme Court filings. But the costs of using these printers and doing these 40 copies of these specially formatted briefs, it can run to several $1,000s just to file a brief. So it's not cheap at all. So the court has a process, the IFP process, where a petitioner can make a motion to be treated as a pauper. That's the the old term for informa pauperis, meaning they can't afford the fees and costs related with filing. And what the court does is it waives the filing fee and allows a simplified format on regular 8.5 by 11 paper with fewer copies, just to reduce the cost there. Now, a lot of people in this category are incarcerated prison inmates who are filing briefs with the court, and they would qualify for this this kind of treatment. But it doesn't have to be. Some people are not. They just can't afford those kind of filing fees. So what does this order mean? Well, the language there where it says, the clerk is directed not to accept any further petitions in non-criminal matters from petitioner unless the docket fee required by Rule 38A is paid. That's the $300 fee I mentioned. And the petition is submitted in compliance with Rule 33.1. Now, Rule 33.1 is extremely detailed formatting information about the exact size of the paper and font and margins and all that stuff. So that's basically saying this person is no longer eligible for the IFP status. If they want to file something else and it's another civil filing, they need to pay the full fee and follow the rules like all the other paid individuals. So that's the basic meaning here. This is what this is about. So why does the court do it? Well, there's no way to know in any particular instance without checking the individual docket and trying to look up on it. But most likely it's because someone has made numerous frivolous filings to the court, or perhaps repeated filings making the same legal claims after being denied previously. Just as an example, I checked a petitioner who was subject to this type of order just a few weeks ago, and she had, by my count, 11 unpaid petitions in the last 5 years. And I checked several of them, and they were all accusing various courts and other government officials of various wide-ranging conspiracies against her, just with various different facts, but different conspiracies by different government officials. So apparently 11 was too many, and the court drew the line and didn't want to hear any more of these unless she was willing to pay full freight. So when does the court draw the line, though? That I can't answer. I have no idea how many filings it typically takes or whether there's any consistency. I don't know. It's an interesting question. I wonder if anyone's done any research into that, but I don't know that. But that's some basic background on what that language means and what that's all about. Moving on to the next question, also related to the orders list. The next question is, when the miscellaneous orders list comes out, this is referring to the regular orders list. When the orders list comes out, occasionally there's an attorney discipline section. What does that process look like? What do people typically get disciplined for? Are many people successful at showing cause why they shouldn't be disbarred? Also, is it just disbarment from practicing in the Supreme Court, or is it all courts? So that's an interesting question. So first, I want to give a little background about the Supreme Court bar, meaning those lawyers who are allowed to practice in the Supreme Court. Now, in fact, becoming a member of the Supreme Court bar is not actually a very difficult process. There's a pretty simple process. All that it requires is that someone have been a member in good standing in their state bar for at least 3 years, pay a $200 fee, a one-time fee of $200, and have 2 sponsors who are current members of the Supreme Court bar. So it's really not very onerous. Any lawyer who's been practicing for more than 3 years and is in good standing and just has to find 2 sponsors to allow them to join the Supreme Court bar and then be licensed to practice in the Supreme Court. So there are thousands of lawyers across the country who are members of the Supreme Court bar. The overwhelming majority of these have never and will never practice before the Supreme Court. Some people do this just for kind of the prestige or maybe resume padding, just like to have the nice certificate on their wall that says they're a member of the Supreme Court bar. There is one particular perk, which is that at oral arguments at the court, there's a special admissions line for members of the Supreme Court bar, which allows them to get into oral arguments sometimes even when there's a long line for the general public seating. And there's also an overflow lawyers lounge when courtroom seating is full, so people can still get into the building and hear oral argument from another room. So that's one perk that exists of joining the bar. But again, most of those people have never actually practiced at the Supreme Court. They're just joining to become a member of the court. Now, these orders and the attorney disciplines orders that show up on the orders list, generally these discipline notices have absolutely nothing to do with misconduct at the Supreme Court. So what happens is when an attorney is disciplined by their state bar, so for example, someone is suspended or disbarred for some sort of misconduct in whatever state they're licensed to practice in, that state will notify the Supreme Court. And that's when the Supreme Court puts one of these orders to show cause, the notices that give say there's basically 40 days to respond to this notice that you're going to be disbarred. But the Supreme Court requires, to be a member of the Supreme Court bar, you're required to be in good standing in the state bars to which you belong. So basically, disbarment from the Supreme Court pretty much follows automatically from being disbarred or suspended from a state bar. So in the overwhelming majority of these cases, there's probably nothing for that attorney to do. They're just 40 days, and they're going to be put on the list to be disbarred from practice in the Supreme Court, because once they've been disciplined by their state bar, they're no longer eligible at the Supreme Court. So these aren't things that are typically litigated at the Supreme Court. It's pretty much something that just follows automatically from the state disciplinary process. Now, there are some interesting twists sometimes. Earlier this term, there was just an interesting incident that got some press, where the Supreme Court had accidentally published one of these orders to show cause against the wrong attorney. There were two attorneys with the same name, and one attorney had been disbarred, and the other attorney was a member of the Supreme Court bar and was given one of these notices. And the Supreme Court, when the court was notified that it had made this mistake and had gotten the wrong person, they corrected that and rescinded that. But it was so that 40 days notice kind of allows a chance to correct the record if a mistake like that happens. But that's just a outlier. Most of those cases are just going to be automatic disbarments. So that's all for the orders list. So Ryan Briggs had one other question, and this is related to special masters. And this question was, when the court has original jurisdiction in a case, how do they pick a special master? Are there special qualifications? Is there a pre-approved pool? So this also requires a little bit of background. For listeners who don't know what I'm talking about here, let me back up a bit and kind of work my way to that question. So first, original jurisdiction. Now, I've talked about this a little bit in the past, in podcast episodes in the past, but here's what that's about. The Supreme Court is normally an appellate court. It's a court that hears appeals. It reviews the decisions of other state and federal courts, and that's referred to the court's appellate jurisdiction. So that's the normal way the court functions, and that's what the overwhelming majority of the court's business is: cases that were brought in some lower court, whether in the state or federal system, and then make their way up to the court on appeal. But the court also has what's known as its original jurisdiction. Now, this is narrower. It's specific types of cases that can be filed directly in the Supreme Court, not filed first in a lower court. There's several different categories of these, but the most common category is when one state of the United States is directly suing another state. So state versus state action gets brought directly in the Supreme Court. And the most common types of these, in at least in current times, are interstate water disputes. There's lots of disputes relating to rivers, river systems, reservoirs, et cetera, that cross through more than one state, and one state suing another for overuse of their allocation of water from the river system under various interstate compacts and things like that. And those cases are coming up fairly regularly. You see, I think almost one a year on average of those type of water disputes. There was 2 water disputes, original water disputes, on the court's docket this year, but it varies from year to year. So special masters. So I mentioned the Supreme Court is normally an appellate court. It hears appeals. It's not a trial court. And for the most part, the justices on the Supreme Court don't have any expertise in running a trial court. Of the current 9 justices, only one of them, Justice Sotomayor, was ever a trial judge. The rest of them have never served in that function. Now, trial courts they're responsible in our system for developing the evidentiary record. They hear testimony, they review evidence, they take expert reports, things like that. And trial courts also serve an important process of kind of through various motions and things, they identify and kind of narrow down the key legal issues that are really under dispute in a particular case. And appellate courts, on the other hand, they normally deal with a fixed, more limited factual record and a narrower set of disputed issues, because by the time something gets to appeal, most things have been already decided or kind of resolved more or less by the trial court, and it's only narrower issues that are coming up to the Supreme Court. So it's very different processes. Also, the trial court process can be incredibly time-consuming. It may involve numerous hearings, motions, direct testimony, a voluminous record, things like that. So the Supreme Court, it doesn't want to waste large chunks of its time doing work that it really isn't well-suited to doing on cases that it may not deem to be as important as its normal appellate docket, the cases that it chooses to hear from cert petitions. So what's the solution? What the court will do is it will very frequently, it will, when it gets one of these original jurisdiction cases, it will appoint a special master and who will be assigned to have certain responsibilities over the case. Now here, I'm going to read. This is a kind of typical language that the court uses when it appoints a special master. It says, it names a particular person, and it says this person is appointed special master in this case with authority to fix the time and conditions for the filing of additional pleadings, to direct subsequent proceedings, to summon witnesses, to issue subpoenas, and to take such evidence as may be introduced and such as she may deem it necessary to call for. The special master is directed to submit reports as she may deem appropriate. So you can see from that language, it's very broad, it's very discretionary. It's basically the court just saying, special master, you take over, you run this case. And the Supreme Court is kind of handing this case over to the special master. Now, the special master is essentially acting in the role of a trial judge in the case. The special master will go and conduct hearings, decide motions, take testimony, eventually issue a report, and that report is basically the equivalent of a judicial opinion. And that process, in some cases, can take years to play out. The litigation may go on for years and have various, proceedings, hearings, motions, etc., before eventually a report is issued, which is, as I said, kind of the equivalent of a judicial opinion. Now, once that report is filed by the special master, the parties can do what's called making an exception to the report, and that's basically the party disputing some part of the decision of the special master. And then those exceptions are briefed, and the Supreme Court can then rule on those. Exceptions. They can overrule the exception and uphold whatever the special master did, or sustain the exception and reverse some part of the special master's decision. So essentially, that converts the Supreme Court's role in the case into something much more like an appellate court. It's allowing the special master to kind of serve as the initial trial judge, and then the Supreme Court is just standing in review of the special master's decision. So that's just some background on what this is all about. But then getting down to who are these special masters? Well, there are no formal qualifications, and there's no specific pool of people. Now, the court used to generally appoint retired federal district judges for these type of things, and these were this made a lot of sense because retired district judge is someone who has experience running trial courts, including in complex litigation, and they tended to be relatively cheap compared to many private practitioners. So that used to be kind of the standard practice, but now the court is more often using private attorneys, often someone with expertise in the particular field at issue. This may be a practitioner, a lawyer at some law firm who practices in the area but is not involved in the particular dispute at issue, or maybe an academic. Sometimes it's a professor who teaches and writes in the particular area at issue. Someone that deals with land and water use issues, for example, might be called in to be a special master in one of these cases. As to how the court selects a particular special master for a particular case, that I do not know. The court typically does that basically as soon as it decides to take an original jurisdiction case. It has some discretion over whether to take these cases, and as soon as it grants one of these cases that it's going to take it and add it to its docket, it generally immediately appoints a special master. And the dockets in these cases don't reflect any consultation with the parties. It seems that the court just chooses someone that it appoints. So exactly how they come up with the person for a particular case, that I don't know. But my assumption is it's a case-by-case determination based on the particular legal issues and whether there's someone with relevant expertise. I had one other just kind of broad request. This is from Reddit user JimWilt20. Just asked about any interesting potential future grants. We've been talking a lot lately about the cases on the court's docket this year, the opinions that we're waiting for over the next 2 months, and the cases that they've granted for next year. But what else is out there that isn't on the court's docket yet, but maybe in the future? First, I'm going to talk just briefly just about where you might find cases that are good candidates to make their way onto the court's docket, and then I'm going to talk briefly about two cases, or two, I guess, legal issues, legal disputes that I think have a very solid chance of making it up to the court in the relatively near future. I'll get to that in a minute. So just for background, I mentioned again that somewhere in the ballpark of 70 cases will be granted per term. This term is very low. The court only heard 63 argued cases, and it's yet to be seen how next year's docket will end up, whether it'll be also another light year, or whether the court will be picking it up a little more and granting more cases. But where will the cases come from to fill out the rest of the court's calendar for next year? Well, I mentioned the court receives about 6,000 to 7,000 petitions a year in recent years. That means if you do the math, it's somewhere in the ballpark of 120 to 130 new petitions a week. And on average, you're only going to have 1 to 2 of those out of every 120 to 130 petitions filed in a given week. Only 1 to 2 are going to be granted. So the court is kind of winnowing down a pretty large pool into a pretty small number. So how might you find cases that are good candidates? Well, the best place to look if you want to see just petitions that are already up at the court. So these are things that have already been filed and are pending, waiting there for the court to consider, that have a good chance of being selected. The best place to go, and this is a resource. It's anyone who wants to learn more about the Supreme Court and really wants to follow the court closely and kind of just learn more about everything that's going on with the court. Should go to a website called SCOTUS blog, scotusblog.com. And that's kind of the premier private website that tracks the court and provides news and analysis and commentary on the court. And SCOTUS blog they have important resources. They keep case pages that have links to various briefs and other documents filed in various cases. It's a great resource. They also have analyses of upcoming arguments and analyses after the fact, after oral arguments, and opinion analyses, just various very intelligent analyses done by experts in various fields. So it's just an all-around great resource for someone who does want to follow the court closely. But it has a few specific features that are directed toward cases the court has not yet granted. Now, one of those is a feature known as the Realist Watch. And this is something that's done by attorney John Elwood. He's a attorney and member of the Supreme Court Bar who's argued cases at the Supreme Court and is often a frequent filer of amicus briefs and other filings. Now, this is a recurring feature at SCOTUS blog where he analyzes and tracks relists. So what are relists? When the court gets these petitions, the court periodically schedules a certain set of these petitions to be up for discussion at a particular one of the court's private conferences. So I mentioned that the orders lists come out following the private conference, and those orders lists are generally where new granted petitions are listed and denials of petitions are listed. So the court will set a certain number of petitions for consideration at a particular conference. And what happens is after a conference, maybe some small number of those petitions will be granted. A large number of the petitions that are set for that conference will be denied. But some of those petitions will also be relisted. And what that means is they will be set for consideration again at another future conference. So instead of being either granted or denied, they're relisted to be discussed at a future conference. Now, there's multiple reasons this might be done. Sometimes this is because the court has not voted to take the case. The court has voted to deny the petition, but one or more justices disagrees with that opinion or that decision and perhaps wants to write one of these orders relating to or dissenting from the denial. So one of these orders opinions related to an order. They want to write an opinion relating to the denial, dissenting from the denial, and explaining why they think the court should have taken the case. So that may be a reason it hangs around. But it may also be that certain members of the court are still on the fence. They're still trying to decide whether or not this is a case that they want to grant, and they may ask to have the case relisted so they can give it more thought, or an attorney or a justice who wants the case to be granted but doesn't have enough votes to grant it may ask it to be relisted because they're trying to still persuade one or more of their colleagues to change their mind. And also a practice that seems to be becoming more common in recent years is many petitions seem to be just being routinely relisted at least once before they're granted. And the general the consensus is that what the court is trying to do is doing, when the court decides it wants to take a particular petition, doing a last bit of extra due diligence just to make sure that there aren't any particular problems with that case that's going to make it not actually a good vehicle for deciding a particular legal issue before they make the final decision to grant the case. So the relist watch feature will, after each given orders list, will analyze what cases have been relisted, and sometimes cases have been relisted multiple times, meaning they've been up at multiple conferences and keep getting relisted. And relist cases are very good candidates for potentially being granted. A good number of those will eventually become granted cases. So that's one place to look for upcoming, potential upcoming cases where there may be interesting cases. The other interesting feature at SCOTUS blog is they have petitions to watch for a particular conference that's coming up, where they will list a number of petitions that the people who run SCOTUS blog believe to be have a better than usual chance of actually being granted by the case. So the petitions seem to be well presented and show a legal issue that the court may be particularly interested in. And the SCOTUS blog also has a petition of the day where they post a single particular petition that they're kind of highlighting as particularly interesting. And those are all things to look at if you want to see what's up there before the court that the court might potentially be interested in taking. But of course, there's no guarantee of any particular case is going to be taken. But that's just things that are actually petitions that are actually pending at the court. But beyond that, you have all the various cases that are at any given time are working their way through the lower state and federal courts. And there's thousands and thousands of cases out there, most of which are dealing with matters that are just the court would have no interest in taking, routine legal decisions that don't really have any great importance, things like that. But occasionally there's some very interesting and obviously either high profile or just where there's obviously a strong division of opinion that look like good candidates for the court to potentially take. So I'm just going to talk briefly about two of these, and these are both things that I think are strong candidates for making their way up to the Supreme Court relatively soon. And the first is about the treatment of sexual orientation discrimination under Title VII. That's the employment discrimination statute. And Title VII protects against discrimination on the basis of sex, but it does not explicitly mention sexual orientation. Now, in the last 2 years, there have been 2 different circuit courts. There's the Seventh Circuit in 2017 in a case called Hively v. Ivy Tech Community College, and then earlier this year, the Second Circuit in a case called Zarda v. Altitude Express. In each of those cases, those circuit courts held for the first time in each of those circuits that Title VII's bar on discrimination on the basis of sex covers discrimination on the basis of sexual orientation. Now, this is very interesting because there's Title VII is a pretty old statute, and there's longstanding precedents in various circuits holding that sexual orientation discrimination is not covered under Title VII, and at least I'm not sure about the Seventh Circuit, but in the Second Circuit, it was explicitly overruling a previous Second Circuit opinion that had explicitly held that sexual orientation discrimination was not covered by Title VII. So there's a very clear circuit split on this issue of whether it's covered, and there are arguments, legal arguments that at least facially strong legal arguments on both sides. The argument for it bases a lot of the argument is based on longstanding case law about what's referred to as sex stereotyping, saying that stereotyping people on the basis of what's considered kind of typical or stereotypical traits of men or women, and treating people differently on the basis of those stereotypes is a type of sex discrimination that's covered by Title VII, and the argument kind of flows from there that sexual orientation discrimination kind of fits under this model of stereotyping and should be covered by sex discrimination. On the other side, there's an argument based on this long history and also pointing that other statutes explicitly include sexual orientation as a protected category, and this statute doesn't. And also that there's been action in Congress to try to amend various non-discrimination statutes to include sexual orientation that hasn't been successful in many cases. So so there's kind of arguments on both sides about how this older statute should be interpreted in the present. So I don't, as far as I know, I don't believe these cases have been petitioned up to the Supreme Court. I don't know if there's any petitions pending right now on this particular issue, but it seems like an issue that's kind of primed to make its way in the relatively near future to the Supreme Court, and the court will likely weigh in on that. So that's just one issue to watch that may make its way up to the court. The other issue, and this is kind of on another very politically divisive issue, is related to the DACA program. That's the Deferred Action for Childhood Arrivals immigration program. Now, just a little background on that. The DACA program, it was a program enacted by President Obama through a Department of Homeland Security memorandum. So this wasn't anything enacted as legislation from Congress. It was done purely as an executive branch action. And what it did was certain immigrants who came to the United States as minors are given the ability to obtain a deferred action status, which allows them to remain in the country for a limited period of time without fear of deportation. It's only for a limited period of time and needs to be renewed periodically in order to continue that status. But that was a program that was enacted by the Obama administration. Now, last year, the Trump administration under Attorney General Sessions issued an order rescinding the DACA program. So rescinding the memorandum from the Obama administration that enacted this program, and so they were acting to undo this program. Now, multiple lawsuits were quickly filed against this rescission, and at this point, several district courts across the country have held that the rescission was unlawful and issued orders ordering the Trump administration to continue the DACA program. And there are challenges continuing in the various lower courts, but it has not yet made its way all the way up to the Supreme Court. And so that seems like another case that's has a good chance of eventually making it to the Supreme Court. Now, there have been attempts in Congress to reach a legislative solution to the DACA issue. There have also been talk about the Trump administration kind of redoing its rescission in a way that might be legally stronger and might stand up to some of the lawsuits that caused it to be blocked. But so something could happen that kind of changes the facts on the ground and prevents this kind of moots the case. But if that doesn't happen, it seems like a likely case that might eventually make its way up to the Supreme Court. So those are just two things that are out there that I'm keeping my eye on. There's lots of other interesting things out there, but I think that's about enough for tonight. I think we've reached the end of our hour, and it brings me to next week. Our next live stream will be a week from today. That's Thursday, May 17th at 9 p.m. Eastern Time. And that is our usual weekly live stream time, Thursdays at 9 p.m. Eastern Time. And you can always check the Counting to 5 YouTube channel to find the next scheduled live stream. Now, next week's live stream, the court, as I mentioned earlier, had its private conference earlier today. An orders list from that conference is expected on Monday morning, so that might include new grants for next term. But also the court's public information office has said that opinions are likely Monday morning. So we are expecting one or more opinions issued on Monday, this coming Monday. Now, just as a reminder, there's only 7 weeks left in the court's term, and the court has 39 cases that we have yet to be decided. So, that's 5 to 6 cases a week on average. Now, it's likely to be backloaded more toward the end of the term. That's the typical pattern. But it would not be surprising to get multiple opinions on this coming Monday. And again, the court's schedule from this point on is that it has a conference every Thursday, and it has a scheduled sitting for orders and potentially opinions every Monday. And almost certainly, based on past practice, the court will add additional opinion days to its calendar later in the term. So in June, the court will start adding additional days, so not just Monday, but additional days in the week when it will issue opinions just to get more opinions out. Just based on recent years' past practice, the court pretty much never issues more than about 5 or 6 opinions in a given day. 6 is about the max they ever issue at once. So if they kind of get really backlogged toward the end, they will add additional days and spread the opinions out a little more. So that will be, they will finish up probably the last Monday of June, but maybe they'll have an opinion day later in that week and finish up later in that week, and we should get all 39 of those opinions. So that's what we're looking for the next rest of the term. But again, next week's live stream, we will hopefully have opinions to talk about and maybe some newly granted cases. Whether you're watching on YouTube or listening to the audio podcast, I would love your feedback. You can leave comments on the show notes at countingto5.com, on the Counting to 5 YouTube channel or Facebook page. You can tweet at countingto5 or send an email to mike@countingto5.com. Please subscribe to the Counting to 5 YouTube channel or audio podcast to make sure you don't miss future episodes. And thank you for listening. This has been Counting to 5.